This is TWiT.
But I guess I should really talk about the judge blasting Apple for lying on the stand. Judge Yvonne Gonzalez Rogers of the U.S. District Court in Northern California said Apple violated an injunction the court issued in this Epic versus Apple case. They won the case pretty much, except for that one thing where the judge said, Apple, you got to let app developers offer methods of making purchases outside of the App Store.
Yeah.
Apple did that malicious compliance thing it does so well. She wrote, Apple, despite knowing its obligations thereunder, thwarted the injunction's goals and continued its anti-competitive conduct solely to maintain its revenue stream. Remember, the Apple decided to impose a 27% commission
Yeah.
instead of 30 in off-app purchases. And in her ruling, the judge said, Alex Roman, who I'm not familiar with, but he's VP Finance, quote, this is the judge, outright lied under oath. She said that Cook sided with his finance team instead of another Apple executive, Phil Schiller, who advocated that Apple comply with the injunction. She wrote, Cook chose poorly.
Yes.
The nicest 3-word sentence ever.
I mean, like, you gotta read this entire ruling because she was very, very
livid,
steamed, and was not like this is not a negotiation. This is a ruling which you have to comply with. And like it felt like every time as a kid when your parents were so angry with you that they were talking calmly and said, so because you didn't want to ride the bus, you then thought, I know, they're the keys to Dad's car. I'll just take the keys and drive myself to the movies, even though I'm 14 years old and don't even have a learner's permit. Following that, it was on and on and on again.
Judge Rogers has referred the situation to the U.S. Attorney's Office in San Francisco for criminal contempt proceedings. Apple, meanwhile, immediately appealed.
Yep.
Apple said, no way. However, everybody else jumped. Epic Games says Fortnite's going back, baby. And Amazon has already put a buy it now button on its Kindle app.
Yeah.
So, this is, I mean, absolutely.
Yeah. And
this is what the judge ordered.
And let's just be super clear. Like, this wasn't he said something, Alex, he said something that turned out not to be totally true. It's like in the actual testimony, you knew that he was cooked because Epic's lawyer said, wait a minute, you're saying that the decision to charge 27% for any transactions that follow from following a link or a button out of the App Store, you decided it on this day and not before. Like, he asked for clarification. And so when Epic decided to sue, saying, look, you're doing malicious compliance, you're not complying with the order, they got access to a whole bunch of Apple internal communications in which, it turns out that they've been discussing this for months and months and months, first under Project Michigan and then under Project Wisconsin. And they had decided on that figure, not as he testified that, well, we hired an outside consultant to decide what that percentage should be. And that's why, and we decided to heed the advice of this outside consultant. Whereas all of the stuff they got through discovery was, we literally made the decision that we want to make this as painful as possible so that there's absolutely no reason whatsoever to encourage a developer to not do in-app purchases. It was like bam, 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 bam. Every point of this, Apple was dead to rights, and judge was not amused.
And I have to say, as a lawyer's son, it is idiotic to have these conversations over email.
Yes.
Like, what are you doing? Like the dumbest part of this whole thing, and to me, was why are you having these conversations in writing, you idiot? If you're going to have a conversation like this, if he goes to jail or if he has to get fined or whatever, he deserves it just for them being stupid. This is an unforced error in their entire process of this is the reason I joke oftentimes that a lot of representatives don't use email. One of the big reasons they don't use email is because they don't want to have any trail, right? They just don't want to have written. They're all lawyers, and most lawyers know, don't say anything every email, like the thing that's going to be hilarious when we talk about this 5 years from now, all those little AI transcripts that are working for you, those are actually you can be subpoenaed, and like, did you have any of those, and submit all of those as well. And so the thing is like that, people doing that is also crazy. But the fact that they started talking about strategy over email is insane. Like, especially after they have already been sued once. At some point you go, oh, I lost some data on my drive. Maybe I should never do that again.
Yeah.
And then you just started saving stuff to your drive again. like, oh, I'm not going to back that up. I'm just going to throw it on. But it was like they learned nothing from this.
I hope Apple loses on appeal, because this is obviously the way it should be. Here's what this is from Jeopardy contestant Dan Morin writing in sixcolors.com. I didn't see the show yet. Don't tell me how.
Yes, tomorrow? Yeah.
Was it tomorrow? I thought it was yesterday. Is it tomorrow? Okay.
I thought it was the 7th, but good name.
It's the 7th, maybe. Okay, good. So future Jeopardy contestant. Dan has the screenshot from the Kindle app. He said, then I went to check the Kobo app. They also have a get book button, but they also include Apple. He writes it, Apple's now prohibited scare screen.
Yep.
Which they could get rid of, and probably should. So it's only a matter of time before everybody does this. Maybe there's some nervousness that on appeal that it'll be reversed. I can't imagine it will on appeal.
What's wild is this was from a court case in 2021. That was when
it took
this
Epic
order
forever.
came.
Yeah.
Well, and it's taken Apple forever to actually comply, because they've now had 4 years to make the changes that the judge ordered. And that's why she's so mad, because they took 4 years to deliberate this and chose the most malicious compliance option possible. And if listeners and viewers aren't aware, this was strictly just to allow developers to link out for customers to purchase subscriptions outside of an app, outside of Apple's tax. And Apple literally won everything else from that Epic case. Epic wanted a game, third-party game stores in the App Store like they now have in the EU because of the Digital Markets Act. And Apple won so much of that case, except for this one thing, anti-steering, allow developers to link out to the web. And because Apple chose to really not comply, now it's on them. And now there's lots of apps, even like Patreon jumped on this, which they were going to redo their entire payment system. But now that they can link out in the Patreon app so people can support creators that way, they're going to redo their whole app and take advantage of this. They don't know how long it'll last, but I don't think that you could put the genie back in the bottle.
Well, that's what I think that's what they're trying to do, is everyone's trying to make sure that they provide a bunch of services to show people what they'd be missing out on if this goes back in. Because the reality is that while she's very upset, the judge is not totally accurate. So they did what she said. They just didn't do it the way she wanted to. By the letter of the law, she said you have to give people access. She didn't say how to give them access. And while she can talk about malicious content, until you prescribe exactly what they need to do, there's a lot of openness there about what they can and can't do. So so the thing is they did what she told them to do. They just didn't do it the way she wanted them to do it. And so she's upset about that, and she's going to write a long letter, but it's going to go to the Court of Appeals, and I would give it 50-50. And I think but I do think that there's a relatively good chance that the Court of Appeals is going to, I think it's probably 70% that the Court of Appeals will file an injunction that will stop anything from happening until it gets to the Supreme Court. But given the past Supreme Court rulings, the chances of Apple succeeding are actually probably not. They'll buy time, but they're not going to. At this point, they're probably going to lose this one. And so, but
the heart of that Apple fight.
Also, just quick note. Apple already tried to appeal this to the Supreme Court. The Supreme Court said, "Nah, we're not interested." That's after losing their first appeal. So I don't
preemptively, both Apple and Epic ran it up the flagpole and were turned down.
Two different things, though. The first time that they took it to the Supreme Court, they said we should strike this all down. The second time, we did what we were told to do. We followed it, and now we're being told we have to do more, but we weren't prescribed that explicitly in the first ruling. So the two cases are very different as they go to the Supreme Court. If the Supreme Court looks at just the case it's in front of them now, the question is, did Apple by the letter of the law, maybe not the spirit of the law, and spirit doesn't exist. Like, it's like it doesn't really exist.
All you have to do is follow the letter. That makes sense.
All the letters.
Yeah.
So they followed the letter. They allowed apps to link out. It didn't say they couldn't put other things into it or charge them or do anything. It didn't, that wasn't prescribed in the initial ruling of what they can and can't do. Now, she could rule again and say you can and can't do all these things. But to say that they're in contempt of court for not doing it, I think that's a much weaker case than just going ahead and prescribing like, hey, you got to turn all this other stuff off.
Yeah, it's not a slam dunk. However, and of course, speaking as an absolute legal expert, no. I spoke to a couple of attorneys who litigate stuff like this, and they said that after having read the ruling, after read the original order, these two individuals felt as though the judge was very, very clear about what the corrective action needed to accomplish. And the fact that it wasn't just, oh, well, we'll charge you 27%. It's also, we're going to put in all kinds of scare screens to make sure the user will be too scared to actually enable this. We're going to make sure that the developers who take advantage of this will have to not only track usage of that button, purchases that happen through that button, but they're going to have to track it for 7 days afterward. Any person who buys something from this external store within 7 days after clicking the button is owed 27% tariff. 27% is owed back to Apple. Bam, 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 bam. And also the internal communications, as you said, is really hard for a judge to ignore, that they were actively discussing. They stopped just short of saying, how can we absolutely screw everybody except for ourselves? How can we choose an option in which the least of what the judge is telling us to do is actually done, and that no developer and no user will avail themselves of this poisonous tart of turds that we have built inside the App Store to implement this. So that's why I agree this is not a slam dunk, but my understanding right now is that Apple has an enormous hill to climb to get over this. They have 90 days to comply. And so you're right, they could issue a stay of this. It looks as though people are betting that, as you say, let's make sure that people see how good it is to be able to actually buy a book after that's being recommended in the Kindle app and be taken to a link to the Amazon store and buy it from there and not have to deal with all that hassle and find out that, wow, Apple has said that the entire world will come to an end if this is allowed, and it turns out the sun still rises and sets.